Good afternoon, everybody. I'm accompanied by Dale Clift, NA1L, who's hiding behind me, and Bob Familio, K3. Dale is NA1L, who in his deep, dark, and distant past actually worked at ARRL. Bob Familio, K3RF, is the director for the Atlantic Division. And I'm Fred Hopengarten. I was formerly a director from New England, but I want to emphasize to you very clearly I am not representing the ARRL in any remarks I make here today. So let there be no mistake about that, and I hope the recording captures it. We will entertain questions, and we have the fortunate occasion today that at the end of our time, the next group of guys fouled up and gals didn't show and aren't showing up. So we're going to have extra time for questions. At this session, we normally have more questions than we can possibly respond to during the course of it because everybody wants to get free advice from a lawyer, which I assure you is worth every penny you pay for it. In any event, I'm Fred Hopengarten. I'm K1VR. And if you want to see some more stuff in depth about the process of getting a permit for your antenna, there's a 6-part webinar presentation available on the ARRL's website. And unfortunately, the URL is too small for you to read, but I guarantee that if you send me an email and I'm not hard to find, just go to antennazoning.com, you find me. You'll be able to capture this URL, and each of these sessions is about 20 minutes long, which is far more detail than we can ever possibly get to in a public presentation like this. And what I thought I would talk to you today about primarily, and I'll bring up another thing later, is the text of the bill that the ARRL has before Congress right now. And I'm going to give you some of the inside detail and a little bit of the understanding of why we took the approach that we did. But since everybody in Boston is now speaking Latin and wishing they went to Villanova, I thought I would begin by saying legem propositam habemus, which means we have a proposed law in Congress. It has been reintroduced in this session by Senators Wicker and Blumenthal, and you'll notice the R and the D, so it's either bipolar or ambidextrous kind of a bill. And the same thing in the House. We have a Republican and a Democrat sponsoring the bill, H.R. 1094. And these are good guys. And one of the most important things is that Blumenthal is the senator from Connecticut, and Courtney is one of the 8 representatives from Connecticut. And in the Congress, if you're going to try to get a bill through, you really have to have the support of your what's called home delegation. If they're against you, it's going nowhere. And so far, we've signed up, I think it's 7 of the 8, might be 6 of the 8 Connecticut representatives. It's an entirely Democratic group of congressmen from the state of Connecticut. In any event, Blumenthal is a senior guy, and that's very helpful. Senator Wicker is in another role, the chairman of the Armed Services Committee, which is a very important post. So he's a heavy hitter on the Senate side. The purpose of the bill is really not to do any, we're trying to invent as little as possible. And our concept, when we were drafting it, it was drafted by N5AUS, Director Stratton of Texas and me, was to try to change the law as little as possible. So the bill is designed to extend existing privileges in federal law, but to extend those privileges to amateur radio operators. And the way we drafted the bill includes this specific sentence. This is language from the bill, that a private land use restriction that prohibits an amateur operator from installing any amateur radio station antenna. Notice it doesn't limit you to 1 antenna or 4 antennas. It's and any amateur radio station antenna may not be adopted or enforced by an HOA. In other words, if you can't have anything at all, that under this statute would be illegal. But there are legal kinds of restrictions. I'll get into those. And the way we wrote it is that the limitations on amateur radio antennas would be illegal if they weren't present in the records when you bought the property. In other words, we're just writing this so that they can't come after the fact and say you can't put up an antenna after you're already living in the HOA. The second requirement we have for limitations on amateur radio antennas is that only the same information that would be required of any other home improvement can be required for an amateur radio antenna. One of the ways that HOAs frustrate the construction of antennas in condos and homeowner associations is by piling on the amount of information you have to provide, licensed contractor certificates, insurance requirements, PE stamps, all of which on the face of them look to be innocent but are really designed to discourage what you'd like to do in way of putting up an antenna. And then the other thing that we ran into and outlaw in this bill is they can't just sit on your application, which was a very common process we discovered in the course of fielding phone calls from radio hams in the field. So we wrote into the bill that if they haven't acted within 45 days, it's deemed approved. Now, we also built in what I'll call safe harbor antennas. These are antennas that you should be able to put up without any further inquiry. No prior approval may be required. And the kinds that we wrote in take advantage of existing federal law. One of them is that you'd be allowed to have an antenna of 1 meter or less in diameter or diagonal. And if that sounds like it's familiar language, it's because the over-the-air reception devices, or OTARD rule of the FCC, which is the law of the land, says that if you want to watch satellite TV with the Dish Network or DirecTV, you are allowed, without further prior approval, without any prior approval, to put up a 1 meter dish. We decided to include the words or diagonal for these odd-shaped dishes, but the measurement is 1 meter, 39.37 inches. And that's an extension of the existing federal law because there's an existing federal law that says you can put up a dish for satellite TV reception. Similarly, but I haven't got a slide here, under the OTARD rule, you can put up an antenna for wireless internet, for a wireless internet service provider, or WISP antenna, to get internet, receiving or transmitting, both, in your homeowner association without the permission of the homeowner association. So what I'm trying to get at here is that we are not changing the agreement you made when you bought your HOA home in ways that are really different from privileges you already have. So there's nothing really sacred about that agreement. It's already been broken by the federal government in several other ways. For example, another way that those HOA agreements have been broken is that as a matter of law under the over-the-air reception devices rule from the FCC, you're allowed to put up a VHF or UHF TV broadcast antenna. And the FCC has received a number of petitions from homeowner associations trying to deny VHF or UHF TV antenna where the individual TV watcher wanted to put it up on a TV mast or pole or short tower. This is an actual photograph of a VHF and UHF antenna covering 54 megahertz up on a tower in a, it's called Brookstone development in Virginia. And it's perfectly legal, doesn't require advance permission or prior approval. And if you don't believe me, you can go read for yourself. It can be found in the Code of Federal Regulations at 47 CFR 1.4000, or just go to the FCC website and look up the OTARD rule. Another thing that you can do today, and we're seeking to extend the federal law, is under the Freedom to Display the American Flag Act of 2005, you're allowed to put up a flag and the pole to support it. So what we figured is we would draft permission for a radio ham to put up a flagpole and be able to create a dual use so that it could be both a flagpole and an antenna. We decided to limit it to 43 feet, because I'm sure you're going to ask, because if you put one of these flagpole antennas in your backyard and your ridge pole or the peak of the roof of your typical house is at 36 feet, an extremely common maximum height for a home, and a 43-footer is in the backyard, it really will be invisible from the street. So what we've done here is to extend the flagpole rule, which you're allowed to have, to dual use. And then we also wrote in that doesn't have to be a flagpole, could just be a vertical antenna. In addition to extending this concept of the flagpoles to verticals, we added one more thing, which was to allow, and we searched and searched and searched, and finally I came up with the phrase minimally visible wire antennas. And here's a photograph of what a minimally visible wire antenna looks like, in my opinion. And this is a real photograph. If you have owned an ARRL handbook anytime since the 1930s, you've probably seen this diagram, which was an antenna, which is just a wire from the house to a tree, and it says between 25 and 30 feet high. And if it looks familiar, it's because the ARRL has published this diagram for decades and decades. And if the objection to amateur radio antennas is an aesthetic objection, I think you'd have to agree with me, it's really hard to see a number 18 wire going from the house to a nearby tree. Now, as I finish up, I thought I'd tell you about something new and different, unrelated to the text of the statute, and that is there's something brand new in administrative procedure law. It started with a case called the Securities and Exchange Commission versus Jarkissi, and the court ruled basically that the SEC cannot be judge and jury and fine somebody without a jury trial. And just recently, like in the last couple of weeks, I guess it is, in April, the AT&T has sued the FCC for attempting to create a very large forfeiture, which is their word for a fine, on AT&T without a jury trial. And the court so far has been ruling, the courts have been ruling that the FCC can levy a forfeiture or the SEC can levy a fine, but you must have the right further to seek a trial de novo, a brand new trial on the underlying facts. You'd essentially go through the same kind of procedure you went before and that you used before an administrative law judge at one of these agencies, either the SEC or the the FCC. So we don't know where the law on this kind of thing is going to go, but if you read the statutes that require a trial de novo, the days when the FCC could fine you and the only way you could go to court would be to overturn it on the grounds that they were unreasonable and arbitrary and capricious. May be over. If you want to, you could seek a trial. Now, this is not a be and all and end all, because you can essentially appeal and go through the process before the FCC if they've decided that you're doing bad things on 14.313. You can do that pretty much on your own, and you just follow the rules. You'd probably be better off if you had a lawyer, but you don't have to have a lawyer. But if you're going to seek a trial de novo in a real federal court, you really want to have a lawyer, a trial lawyer, helping you. So the cost of trying to appeal your $7,000 fine with a trial, it would likely exceed the $7,000 forfeiture being requested of you. This is brand new stuff. I suspect that many, if not all of you, haven't heard about it, so I thought I would bring it to you in this amateur radio and the law forum.